Hello, everyone. Welcome to another ALEC live stream. Today, I have with me Jonathon Hauenschild, the director of ALEC's Center for State Legal Reform and Regulatory Reform. And as a guest, we have Elizabeth Slattery with the Pacific Legal Foundation. She is a senior legal fellow there who is also their resident SCOTUS expert and a co-hosts PLF's podcast Dissents. And today, we're going to be talking about protecting the sanctity of the Supreme Court. Big in the headlines recently, we've heard about this leaked draft opinion coming out of the Supreme Court regarding the Dobbs versus Jackson's Women's Health Organization's case. The SCOTUS draft opinion was leaked about 2 weeks ago to this day, and we've seen a lot of news come out of it from protests and a lot of vocal opposition to the draft opinion. So today we just really wanted to have a conversation about what the leaking of this opinion means, future Supreme, and what we can in the future. So I guess, Jonathon, I'll just pass it to you from there. Let's talk about the processes of the Supreme Court itself, the inner workings of it, and how the leaking of this draft opinion really came to be in the first place.
Yeah, I think this is a good kind of level set. And I know Elizabeth can talk a lot about this, but, for those, let's start at a base level. Supreme Court, 9 justices. Each justice has 4 clerks, and then there's permanent staff on the court. That's the way of doing it. And when a court hears a case, of course, there's briefings from the parties. There's amicus briefs. The judges go back, hold a vote after a hearing on the case itself. Opinions are assigned, and then the process of writing the brief starts. And we can let Elizabeth answer a little more of that, but that's just really super high level.
Yeah, so what we've heard so far about the Dobbs opinion, what happened was that at the conference after the oral argument, the justices took their preliminary vote, and it would appear that the Chief Justice was not in the majority at that point. So from what we can guess, Clarence Thomas would be the next most senior justice on the court. So the assumption is that he assigned the opinion to Justice Alito. Justice Alito got cracking on writing a draft, and the leaked draft came from, I believe, February 10th, which, you would presume there's been more work done since then, because typically the draft is circulated and then the whole court sees it, and the justices would have feedback on that. Even the justices who might ultimately join it would typically have feedback that would be folded into the ultimate majority opinion. So I think what we saw was probably never intended to be the final product.
Yeah, and I think you raise a good point there too. So the way, again, just going back to process, the way court opinions are handed out, so to speak, is if the Chief Justice is in the majority, he determines who writes the opinion. If the Chief Justice is not in the majority, it is the most senior remaining member of the court who determines. So like you said, in this particular case, if the Chief Justice is not writing it, and one would assume a case like this, that if he were in the majority, he would assign it to himself.
Probably.
That if he were not in the majority, the next most senior member of the court is in fact Thomas, and that is assuming Thomas is in the majority.
Yes, and then just as a refresher for listeners, after Thomas is Stephen Breyer, after Stephen Breyer is Sam Alito, and then you get on to the more junior justices. So our assumption is that it was Justice Thomas who assigned the opinion to Alito.
Yeah, right. And we're going to spend quite a bit of time talking about what this means for the future, what we can expect out of the court in the future, and how all these processes may be changed, how they take on clerks in the future, given the suspicion around a clerk potentially leaking this. But right now, let's look to the past a little bit. Elizabeth or Jonathon, are there any prior examples, any type of precedent like this where we've seen a case, maybe not necessarily to the gravity of, potentially a landmark case like Roe being overturned, but something where we've seen, information coming out of the court leaked to this extent, a draft opinion or even votes? What are those examples? What does that look like in the past?
This is certainly the most extensive we have ever seen. There's never been a full draft majority opinion, to my knowledge, that's been released. But there have been leaks throughout history. in the modern era, perhaps most famously, was the leak that came after the court's ruling in NFIB versus Sebelius, which is the Obamacare ruling. There was the leak that Chief Justice Roberts had flipped positions, and he was originally with the unsigned dissenters, which were Kennedy, Thomas, Alito, and I'm forgetting one. Scalia, of course, Justice Scalia. How could we forget my favorite? And there was the news report after the opinion came out that he had switched positions. Going back in history, I mean, Roe v. Wade itself, there was a news story that came out the morning the opinion came out. Apparently, a clerk spoke to a reporter on background. I guess they were classmates, and they had chatted about the case, and the clerk shared what the forthcoming result was going to be. And I suppose there was some sort of an understanding that the reporter would not release the story until after the opinion came out, and the newspaper got a jump on the court by a couple of hours. Famously, the Dred Scott ruling, the horrible ruling from before the Civil War, that was a very leaky court. There were at least 3 leaks, possibly 4, before the opinion was released, was announced. A newspaper ran an account detailing the court's deliberations and ultimate holding in that case. And then there are historical accounts describing how the incoming president, the president-elect James Buchanan, had been enlisted by one of the justices to help lobby votes for the majority. And then finally, one of the dissenters was frustrated that the Chief Justice did not release in the official published form the opinions that had been announced. And so he went ahead and published his dissent in a newspaper. Imagine that today.
As I was looking at this, I've only been able to find one example of a leaked opinion, and it wasn't even like today where it was leaked to the press. It was a clerk leaked an opinion to Friends on Wall Street in 1919 before the opinion. So again, it wasn't like a wide distribution. It was a very limited audience. And yeah, you're right. Throughout history, we've had the leaks of discussions that occurred during the deliberations and the opinion process after the fact. We've even had some leaks of what a decision is going to be in terms of votes. Again, going back to even the Dobbs case, we've heard that it's, the Chief Justice is not assigning the majority. We've heard that it's 5 votes to overturn Roe, but we haven't seen anything. Again, leaks once in a blue moon, but there's two different types of leaks. There's the leak of the draft opinion, which really doesn't have any precedent. But then there's occasional leaks about deliberations after the fact, or what a vote may be.
Yeah, and with Dobbs, before this earth-shattering leak of the draft majority opinion, there was an editorial or a piece written by the editorial board of the Wall Street Journal, I think the week or maybe 2 weeks before, that seemed to suggest that there might have been a leak about some of the internal deliberations of the court. But plenty of what the Wall Street Journal was saying was, what people who are, court watchers had observed, from the oral argument and the speculation that seemed, pretty mainstream, that some people were concerned about where the Chief Justice might be, and that he might be trying to persuade Justice Kavanaugh or Justice Barrett to join him in sort of a moderate, middle of the road position to not fully overturn Roe v. Wade and Planned Parenthood versus Casey, but to still uphold the law that was being challenged. And so that could have been just what people were speculating, or there could have been an earlier leak. But with things like that, it's hard to know. But of course, the Politico story, first ever, this bombshell of releasing a full draft majority opinion.
Right. And I think that's part of why we're seeing such a big, outcry to what the content of the draft opinion is. I mean, it's unprecedented in the gravity, at least. It's a full draft opinion. And abortion is obviously a huge issue. It's along political aisles. It's polarizing. So let's talk a little bit about what's happening right now because of it. We're seeing significant protests to this. Again, it's not an official Supreme Court opinion. They haven't ruled on it. It's a draft opinion. So it gives somewhat of light to, what we may see coming down the pipeline. But the protests that are taking place, as you can see on the screen now, they're not just occurring, in standard fashion on the steps of the Supreme Court in Washington, D.C., but this leaking of the draft opinion has, I guess, taken to the neighborhoods of the justices themselves, the protests against it too. Private neighborhoods of the more conservative justices specifically, you're seeing protests like this take place. So far, they've been peaceful, but I guess the question is, if behavior like this is allowed, if it is legal, if it isn't legal, how far does it go, and where's the line drawn? Further, it makes us ask whether or not these are genuine protests like we see happen, protected by the First Amendment all the time when the Supreme Court is deliberating, or if the leaking and the protests themselves are really just actions of intimidation, and where that line's drawn. First Amendment clearly protects different types of political speech. I guess here we want to kind of explore a little bit, is this crossing too far of a line? I'll pass it to you.
Yeah, well, I think the first thing is we have kind of a distinction about where they're occurring. The night of the leak, Monday night, there were people outside the Supreme Court building, and that's kind of what you'd expect. Both sides of the issue happened Tuesday as well. There were stories of not just the protest, but the fences outside the building. Then we saw kind of a shift. We saw the shift from the protests outside the Supreme Court building to let's go protest outside the justices' houses. And for me, this kind of crosses a line. The First Amendment does guarantee the right to petition your government for redress of grievances. And that's where you see the protests in front of the Supreme Court building. When you're starting to protest outside the houses, to me, I start asking the question of, is this really about expressing your opinion? Or is this about intimidating a justice, a judge, and trying to persuade them through other means to vote the way you want them to vote? In this particular case, you have three basic positions: overturn Roe, keep Roe, and then kind of the middle ground. Are you trying to move justices from one camp to another? Not necessarily from the overturn Roe to the preserve Roe, but to the kind of the middle ground. And this can apply to really any cookie cutter Supreme Court issue, any wedge issue. It doesn't necessarily have to be the abortion issue. It can be really anything that's a cookie cutter. But that's in some respect my opinion. We can get to the law later, but more than happy to listen to what Elizabeth has to say.
Well, yeah, just to jump in real quick. I mean, there is already federal statute that has a civil penalty and criminal penalties for people trying to influence judicial opinions and judicial outcomes of active cases. I guess it comes down to how you define what influencing is, if you're intimidating or not. So if we're asking if these types of protests taking place at these justices' personal homes are legal, I think it's unclear that you can say that confidently, but probably not. Elizabeth, what's your take on it?
Yeah, so I took a look at the federal statute because I've been seeing a lot of discussion of it on Twitter. And it says that picketing or parading near the residence of a judge, juror, witness, or court officer with the intent of interfering with, obstructing, impeding, or with the intent of influencing any judge in the discharge of his duty is subject to fines and imprisonment. So let's say there was a murder trial and people showed up outside of the judge's home or the juror's home. I think most people could conclude what the protesters' goal was. They're trying to influence the outcome of the trial.
Right.
And I think most people would agree that's unseemly and we don't want to encourage that kind of behavior. I think that the justices should be able to feel safe in their homes, regardless of whether it's conservative justices, liberal justices I agree with or disagree with. I think they should all feel safe in their homes. I have to say, I thought it was heartening to see the Senate unanimously pass a bill last week to authorize increased protection to protect the families of Supreme Court justices as well, because several of them have young children, and I would be concerned, as a parent with young kids, I would be concerned about my kids and their safety. If there were people, on the sidewalk outside of my house 24/7, I would be concerned about them.
Yeah, absolutely. And you bring up a great point. I mean, just let's break it down to the lowest level, type of judicial procedure, just a small local criminal trial. I mean, this is the reason that juries are sequestered. This is the reason why judges have to recuse themselves from certain cases if there's a conflict of interest, because we want to protect the legitimacy of that process and make sure that laws are properly adjudicated and carried out. And I think just as you would see on a smaller local level, somebody protesting in front of a trial judge's home, you have the same thing going on here. I think that's a good way to kind of think about this, because it really highlights that this is a different branch of government, so our judicial branch. And it is not a political branch. It's not our legislative branch. It's not our executive branch with a politician at the head of it.
Yeah, I would say the restriction on protesting outside of a home shouldn't just apply to justices. It really should apply to any government official. You have a problem with what that individual is doing as a government official, go present your grievances at their offices. We have a long tradition, even before this country was a country, of recognizing the different character of a person's home. Patrick Henry, a man's home is his castle. That there are certain protections and certain lines we just don't cross around someone's home. Even in law, we afford often special protections for that home, whether it's usually from the government or to protect it. And I think, what the Senate did was incredible, was really good. But I do think we have that line in this country of petitioning a government versus, at the government's place of business, so to speak, or in another public setting versus in a private neighborhood and in a private home.
And I think the bottom line here is that the court is not supposed to be responsive to public pressure. The justices have life tenure. They're supposed to be independent, and it's important that we safeguard the independence and impartiality of our judiciary. And so we shouldn't try to lobby them outside of the normal judicial process. If you want to lobby the court in a particular case, file an amicus brief. That's what people should be doing. They should be engaging through the proper process. But I think this is just kind of building on the rhetoric that we've seen surrounding the court in recent years. I think back to around the time that the court heard the first Obamacare case, between the argument and before the opinion had come out. And President Obama was he gave some speech, and then he had time for Q&A with reporters, and one of them asked him about the forthcoming ruling, and he made a comment about it would be unprecedented and extraordinary if the court overturned that law. And I remember there was an uproar at the time that this was unseemly, this was inappropriate, the president shouldn't be commenting on a pending case. And how things have changed in a decade. We had Senator Chuck Schumer standing outside of the Supreme Court after an oral argument a couple of terms ago, saying that the justices had released the whirlwind and they would pay the price. You had Senator Whitehouse and a group of colleagues that filed an amicus brief saying the court needed to heal itself or face restructuring. During the Trump administration, President Trump leveled personal attacks against judges from the district court all the way up to the Supreme Court when they didn't rule his way. I think this rhetoric is harming the public perception of the court. And so I think we need to demand more of politicians, that they need to stop engaging in this type of rhetoric about the court.
Yeah, I think you're absolutely right. And I was going to make a broader point on the politicization of the court. The framers deliberately took politics out of the Supreme Court through big partisan politics. They're a branch of government. They're going to be political. But they tried to insulate them a little bit from the type of politics that those running for office face. Let's put it that way. And over really the past 3 to 4 decades, we've seen attempts to politicize the court, whether that's, President Trump calling specific justices out, or even back, we now have a verb, borking, whether that's the Senate deciding that they're going to take vendettas out and look at ideology rather than qualifications. You had, like I said, you had the Bork process. You had the attempts to scuttle Clarence Thomas as a justice. The politicization is really, you're right in the sense of we have to be zealous and we have to guard against the politicization of the court. But that's not just on the media, it's also on specifically the elected branches to recognize its role.
Yeah, I think building on that, part of the problem is that we view the court as this body that's going to solve all of our problems, when a lot of times there are big issues that are going up to the court that really should be fought out in state houses across the country, or in Congress if it's at the federal level. But persuading people and agreeing to compromise is not what people want to do. They just want to win. They want to go and get a constitutional right to fill in the blank. And I think that's a deeper cultural problem that we have, that we're less willing to compromise and to work across the aisle. I mean, President Reagan used to say if he could get 70 or 80% of what he wanted, he considered that a victory, and he'd come back for the rest another day. So I think we need to be willing to roll up our sleeves and do the hard work, in our legislatures, because that's where it's the people's actual representatives at work, and not nine lawyers in robes in their ivory tower.
Right, exactly. And I think kind of what the underlying tone of this conversation and what this leaking of the draft opinion shows is that this institution, which is supposed to have this, privilege and sanctity to it, held in high esteem, that trust has been violated in a way. When you have your political branches that hash out the issues, where you do have the winners and the losers, so to speak, there's supposed to be a confidence and a trust that lies in the judicial branch. And I'm concerned, and I think other people are concerned, our viewers, of what that means for the future. Now that this draft opinion has leaked, this is going to be common practice, political tactics and tools and strategies. How is this going to impact how the court does business? Chief Justice Roberts came out and said that this was an egregious breach of trust. He's ordered the courts marshals to launch an investigation into it. So it's not just somewhat light, political news that an opinion got out. I think it really speaks to the trust that the public should have in the institution and where we're at with it now. So I'm curious to get your guys' take on that and the matter itself, and what you think this means for the future of the Supreme Court.
Yeah. So, Chief Justice Roberts did say in his initial statement, where he was confirming the validity of the document, that the court would continue with business as usual. And so far they have. Today was the first scheduled opinion release day since the leak, and the court did not release the Dobbs opinion. So they also didn't add an earlier opinion date, which they could have done. So it does not appear that this leak is forcing them to expedite the process of the case. So I'm hopeful that the court, which has always been, I think, the most collegial body of branch of government, I'm hopeful that they will be able to continue to work together. They're only 9 people, and they have been, you think back to Justice Scalia and Justice Ginsburg, they were about as different as you could get on the bench, but they were famously the best of friends off the bench. And so it's my hope that the justices will be able to put this behind them. I don't know if we'll ever find out, maybe it'll be in the papers someday, in the justices' papers someday, who the source of the leak was and what they did to address it. Or maybe that'll end up, in a Politico exclusive later this summer. Who knows? But I hope they're able to move forward and continue to do their important work together and trust each other.
Yeah, I noted that, I can't remember if it was Thomas. I think it was Thomas that said that the lasting impact is going to be the trust issue. And that kind of makes me wonder, is like, where is that trust going to be? When Thomas is referring to other justices, or is he going to be referring to potentially the clerks or the permanent staff? And it's like, how's that going to change the dynamic of the court? The hope is that it impacts more or less. Let's just assume, since that's the big talk, that it's a clerk, that it impacts the clerk vetting and hiring process. Just for the sake of argument. And it doesn't impact necessarily the collegiality and the working together of the actual justices.
Yeah. So, the sort of conventional wisdom right out of the gate was that this had to be a clerk. We don't know that for certain. Right. The leaked document looked like a hard copy printout that had been photocopied. So, someone could have been careless and left it on a printer. And, there are plenty of individuals inside the court's building. So we don't know
right.
for certain that it was a clerk. And, confidentiality is drilled into clerks at all level, from, any level of a clerkship. And for almost anyone, I think it would be career ending to do something like this as a clerk. Imagine if you go into private practice, how would a firm ever be able to trust that individual to keep matters confidential? If they didn't agree with a particular client or particular position, were they going to, run to Politico or some other news outlet with that information? So I would have to imagine that, the majority of clerks throughout the history of the Supreme Court would understand the gravity of this. And so, if it's a clerk, hopefully it's just one bad apple and it's not a systemic problem that needs to be, screened out in the hiring process.
Yeah. Hopefully you're right. Hopefully someone was a little careless, left a copy up, and it was, a random contractor, janitor.
Let's not disparage the janitors.
True. Random guest inside the Supreme.
Yeah. Who knows?
Yeah. Who knows? A lot of that, leads to a question of kind of what can we do? What can we do going forward? And particularly for something like ALEC, focusing on the state legislators. What can we do? And I've been racking my brains on this all the time. I mean, I think the first and foremost is lead by example. You may disagree with a court ruling, whether that's U.S. Supreme Court or the highest court in your land, but keep the disagreement civil. And if you disagree with its substance, try to find the way that you can constitutionally overcome a bad decision. To engage the political process the correct way. That is through the elected branches. I am open to other suggestions. Obviously, we can, you can do something like increase the security around government officials' homes. But outside of that, I'd love to hear your ideas on that.
I think we need more civic education about the Supreme Court. I feel like, in general, civic education is always a good thing. We can always learn more about our government. But I feel like people don't really understand how the court works. And I suspect if you went to the protesters or the performance artists, as some of them said they were, outside of one of the justices' homes, if you took a poll and asked them, what did the court say in Roe v. Wade and Planned Parenthood versus Casey, they probably couldn't really tell you what the effect of Dobbs overruling them would mean. And to be clear, it means that states can pass laws regulating abortion, and it's up to the people through their elected officials to decide what limits to place on abortion. So I think civic education about the court and understanding that the justices don't just wake up one day and decide, we're going to overrule this case, or we're going to hear arguments on, this other case. They're very much a responsive branch of government. They're waiting for cases to come up to them.
Right. Absolutely. Yeah. Well, let's hope that it was, a janitor being not as careful as he should have been, and it got out somehow, and it wasn't an act, to intentionally intimidate an outcome of the official opinion soon to come. The court goes into recess this July. So we're expected to hear the official opinion then. the official release of the opinion then. So until then, I want to thank you both for joining me today and talking about this issue. Elizabeth, thank you so much.
Thanks for having me.
Your time here. And thank you to all our guests and viewers. If you'd like to, go ahead and subscribe to our YouTube channel for more live stream updates for conversations like this. And thank you again all for joining. We'll see you on the next ALEC live stream.